In this video, I'm going to discuss the nature of sale. And these are the following topics that will be discussed here. The elements of sale, the stages of contract of sale, essential characteristics of sale, and sale distinguished from other similar contracts. So what is a contract of sale? Article 1458 provides that by the contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay therefor a price certain in money or its equivalent. So here there is an agreement whereby one of the parties, called the seller or the vendor, obligates himself to deliver something to the other, called the buyer or the purchaser, who on his part binds himself to pay therefore a sum of money or its equivalent, known as the price. So that is the concept of a contract of sale. So in order to know whether a contract of sale is valid, these three requisites must be present: consent or meeting of the minds, object or subject matter, and cause or consideration. So consent here refers to the consent on the part of the seller to transfer and deliver, and on the part of the buyer to pay. And here the parties must have legal capacity to give consent and to obligate themselves. This is because there are certain persons who are incapacitated to enter into a contract of sale, which will be discussed in the next video. So again, in order to give a valid consent, the contracting parties must have legal capacity, and there is manifestation of the conformity of the contracting parties, meaning there is acceptance by one party of the offer made by the other. And parties' conformity to the object, cause, terms, and conditions of the contract must be intelligent, spontaneous, and free from all vices of consent. In other words, the buyer and the seller know that what they are entering is a contract of sale and that they will be bound by it once they give consent. And the conformity must be real. Second is the object or subject matter. So this refers to the determinate thing, which is the object of the contract. The thing must be determinate, or at least capable of being made determinate, because if the seller and the buyer differ in regard to the thing sold, then there is no meeting of the minds. Therefore, there is no sale. And here the object of the object or the subject matter may be personal or real property. The third requisite is the cause or consideration. This refers to the price certain in money or its equivalent, such as a check or promissory note, which is the consideration for the thing sold. So it does not include goods or merchandise, although they have their own value in money. Otherwise, it is barter. However, the words its equivalent have been interpreted to mean that payment need not be in money, so that there can be a sale where the thing given as payment, but the same must have been first assessed and evaluated, and its price equivalent in terms of money should be first determined. So the price must be real and not fictitious, otherwise the sale is void, and there can be no sale without a price. So, absence of any of these essential elements negates the existence of a perfected contract of sale. So, there are three stages of a contract of sale. First is the preparation or the negotiation stage. Second is the perfection. And third is the consummation stage. In the negotiation stage, this covers the period from time the prospective contracting parties indicate interest in the contract to the time the contract is perfected. In perfection stage, this takes place upon the concurrence of the essential elements, which are the meeting of the minds of the parties as to the object of the contract and upon the price. And consummation stage begins when the parties perform their respective undertakings, culminating in the extinguishment thereof. So the following are the essential characteristics of sale: consensual, bilateral, onerous, commutative, nominate, and principal. So a contract of sale is consensual because it is perfected by mere consent without any further act. A contract of sale is bilateral because both the contracting parties are bound to fulfill correlative obligations towards each other, like the seller to deliver and transfer ownership of the thing sold, and the buyer to pay the price. A contract of sale is onerous because the thing sold is conveyed in consideration of the price. A contract of sale is commutative because the thing sold is considered the equivalent of the price paid. However, the contract may be aleatory, as in the case of the sale of a hope, example, sweepstakes ticket. Also, a contract of sale is nominate because it is given a special name or designation in the civil code, namely sale. And a contract of sale is principal because it does not depend for its existence and validity upon another contract. Now, let us distinguish sale from other similar contracts. First, sale distinguished from agency to sell. So, what is a contract of agency? So, this is where a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. So, in sale, the buyer receives the good as owner, while in agency to sell, the agent receives the goods as the goods of the principal who retains his ownership over them and has the right to fix the price and the terms of the sale and receive the proceeds less the agent's commission upon the sales made. In a sale, the buyer has to pay the price, while in agency to sell, the agent has simply to account for the proceeds of the sale he may make on the principal's behalf. In a sale, the buyer as a general rule, cannot return the object sold, while in agency to sell, the agent can return the object in the case he is unable to sell the same to a third person. In a sale, the seller warrants the thing sold, while in agency to sell, the agent makes no warranty for which he assumes personal liability as long as he acts within his authority and in the name of the seller. In a sale, the buyer can deal with the thing sold as he pleases, being the owner, while in agency to sell, the agent in dealing with the thing received must act and is bound according to the instructions of his principal. Now let us distinguish a sale from a contract for a piece of work. So what is a contract for a piece of work? So this is where the contractor binds himself to execute a piece of work for the employer in consideration of a certain price or compensation. The contractor may either employ his labor or skill or also furnish the material. So the distinction between these two is tested by the inquiry whether the thing transferred is one not in existence and which never would have existed but for the order of the party desiring to acquire it. Then that is a contract for a piece of work. But if the thing has existed and have been subject to a sale to some other person, even if the order had not been given, then it is a sale. In the first case, in a contract for a piece of work, the risk of loss before delivery is borne by the worker or contractor, not by the person who ordered. So, a contract is for a piece of work if services dominate the contract, even though there is a sale of goods involved, and where the primary objective of a contract is a sale of a manufactured item, then it is a sale of goods, even though the item is manufactured by labor furnished by the seller and upon previous order of the customer. Now let us distinguish sale from barter. By the contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. But actually, the rule in Article 1468 for those cases in which the thing given in exchange consists partly in money and partly in another thing is also considered barter. So, in a contract of sale, the vendor gives a thing in consideration for a price in money. So here, in order to determine whether one is sale or barter, the intention of the parties must be determined, and such intention must be ascertained by taking into account the contemporaneous and subsequent acts of the parties. Thus, if the intention of the parties is one of the sale, then such intention must be followed even though the value of the thing given as a part of consideration is more than the amount of the money given. But however, if the in the event that the intention cannot really be ascertained, then the presumption is that it is one of barter. Now let us distinguish sale from lease. So in the lease of things, one of the parties binds himself to give to another the enjoyment or use of a thing for a price certain and for a period which may be definite or indefinite. In other words, in a lease, the landlord or the lessor transfers merely the temporary possession and enjoyment of the thing leased, while in sale, the seller transfers ownership of the thing sold. Let us distinguish sale from dation in payment. So, dation in payment or dasyon in pago is the alienation of property to the creditor in satisfaction of a debt in money. It is governed by the law on sales. As such, the essential elements of a contract of sales, namely consent, object, and cost or consideration, must be present. So, the distinction between the sale and dation in payment is that in sale, there is no pre-existing credit, while in dation and payment there is. In sale, obligations are created, while in dation and payment, obligations are extinguished. In sale, for the seller, the cost is the price paid, and for the buyer, the thing sold. While in dation and payment, for the seller's viewpoint, is the extinguishment of the debt, but for the debtor is the object acquired in lieu of the credit. In sale, there is more freedom of fixing the price than in dation and payment. And in sale, the buyer has still to pay the price, while in dation and payment, the payment is received by the debtor before the contract is perfected. Lastly is the sale distinguished from donation. So sale is a disposition for a valuable consideration with no diminution of the estate, but merely substitution of values, with the property sold replaced by the equivalent monetary consideration. Unlike in sale, donation is essentially gratuitous. Sale is consensual as it is perfected by mere consent, while donation follow formalities and is perfected upon the acceptance by the donee.